next matter board with the hospitality doing business as Iron Pig. This is the Health Department of Northwest Michigan. This is file number 23-193-93C. Also, for various please.
Good afternoon, Your Honor. David Delaney appearing on behalf of the plaintiff, Iron Pig Restaurant. My client, Ian Murphy, is also present. Thank you, Paul.
Deputy Judge Matt Cross, on behalf of the Health Department, and the Health Officer.
Thank you and welcome. So, counsel, as you know, we're here on some oral argument today that was, I believe, requested by each of the attorneys. I just want to go through a brief what I have received so far and reviewed, and then I'll also oral argument to the extent that the attorneys still wanted to offer it. So, first and foremost, I received the plaintiff's, first and foremost, first in my staff, I received plaintiff's motion for declaratory relief. I then also received the brief and response by the Health Department. I also received and reviewed the defendant Health Department's motion for summary disposition and ultimately the reply brief filed by the Iron Pig. I've received and reviewed all of those multiple times over. I'm fairly confident in what I think the attorney's arguments are, but the purpose of oral argument is really to highlight those things that you think are most important or to add some additional substance if you wanted to. Mr. Delaney, it's your case in the sense that you filed the case. Did you have a preference for how you argue either first or last?
I will argue first, and I do not believe I will need rebuttal.
All right, Mr. Cross, do you have an opposition to that?
That's fine, Mr. Judge. Thank you.
All right, so Mr. Delaney, I'm your oral argument.
Thank you. Your Honor, I know the court is well versed in this constitutional area, having previously written an opinion that was relevant. And I also know counsel for the Health Department also briefed this area very well. And so many of my arguments I would prefer to direct to the people that came to watch this hearing, members of the public, whichever side they may be on, for the government or for the business or for on either side. And I know the media is here also. So many of my arguments the court and counsel will know well, and I'm going to stay within that time frame that you gave us. I think you allocated an hour, and I think I would be about a half an hour, but most of it is for the general public because I want them to understand what the non-delegation doctrine means because they hear these things in the media and on the news and they don't understand. So let me get right to that, Judge. And of course, questions at any time. I think that historically, the most important thing to begin with is the Declaration of Independence signed on July 4th of 1976. Thomas Jefferson was the main drafter of that document. But it did not end there. After the Declaration was signed, we tore through 8 years of war with England. And I think that the general public forgets that. It was led by General George Washington. But not until that war ended did the Constitution begin to get circulated among the 13 colonies. The main drafter of that Constitution was a gentleman by the name of James Madison, who became our 4th president. James Madison was 33 years old when he wrote the U.S. Constitution with the assistance of others. And he begins that with "We the People." After the Constitution was enacted and ratified, George Washington, of course, became our 1st president, having oversaw the war after the signing of the Declaration of Independence. Both of those documents, the Declaration of Independence and the U.S. Constitution, were signed at Constitution Hall in Philadelphia, a fabulous place to visit.
Mr. Delaney,
yes.
I'm not in need of background, constitutional or historical fact.
Correct.
This case isn't about those things.
Correct.
So,
I'm ready to move on.
all right.
Thank you.
Go ahead.
And as I indicated, I know the court's well versed in these things, but I wanted the public to understand. And I wanted to understand what James Madison constructed when he put together the U.S. Constitution. And that is, he separated the branches. He had the judicial branch, which this court is in. This gentleman is in the executive branch, and I'm going to appoint this lady as the legislative branch. And he separated those powers was because the king held all those powers. The legislative branch, as the court is aware, writes the laws. The executive branch enforces the law, and this court interprets the law. Michigan's first constitution was drafted in 1835 and has adopted those constitutional provisions. But Michigan has more than that. Michigan has one of the strictest separation of powers in the United States. Other states do too. And that is, Article 3 provides no person exercising one power in one branch shall exercise a power in the other branch. Now, what's important about the Constitution is what is a law? Seems like an unusual question to be asking the court from a lawyer or lawyers that are in the courtroom. The law, importantly, is this. It is the power to regulate people. And a law must be a law, but it leaves the capital in Lansing. It cannot become a law, which is what happened during COVID. The law was not a law. It was just a set of rules and regulations that could become law. And anytime you have that, it's not only invalid, it is not a law. Now, people often complain about the legislature, they get nothing done. Maybe some of that's true. And that's exactly the intent. At the state level, Judge, we have 110 members of the House, 38 in the Senate and the governor. All of those entities must approve a law, and they're regulated and voted out every 2 years. Madison designed that on purpose, so that the legislature would be accountable to the people. And no offense to the judicial and the executive, law writing is the most important of these areas of the branches, which are co-equal, because it regulates society. And I'll give an example for the people that are here. This nice lady, a member of the legislature, has passed a law after going through the House, the Senate, and the governor that red ties are illegal. I'm now wearing a red tie. So what's going to happen? The legislature has no power to enforce that, even though this nice lady in her act of Congress passed this law. And quite frankly, the court can't. The court can say, Mr. Delaney, red ties are illegal, you cannot wear that, but the court has no enforcement power. But that's not the case with this gentleman here, who has a firearm. And we appoint that to the executive branch so they can enforce the laws. He can immediately enforce this law, but that is the only power that he has. He doesn't have the power tomorrow to make blue ties unconstitutional or red ties or change his mind. And so each has their powers. But Madison was very good and generous to the people. I still can come back to this court, the judicial branch, and argue that the red tie law should never have been enacted by the legislature in the first place. But what happened during COVID was that all changed. The non-delegation doctrine, as the court is aware, does not allow the legislature, this nice lady, to give her law-writing power to this nice gentleman in the executive branch. The non-delegation doctrine restricts that by saying what are the standards, what's the scope, and what's the duration. The intelligible principle, which I'll come to later. But there's not only delegation, there's usurpation, which simply means that the executive branch found a law that they think applied to them and allowed them to write law. They weren't given that power, they took it. That happened in October of 2020. Most of the people in this courtroom remember what it was like during COVID in the state of Michigan. COVID tested James Madison. And in the in re certified question, the governor was acting under power given by the legislature to the governor to write laws. And every day that we woke up, whether the governor was a Republican or a Democrat or a Libertarian is irrelevant to me. But the standard for the governor was anything reasonable and necessary. That was it. See, the definition of a law is it must be a law when it leaves the courthouse, the Capitol. If the law is 75 miles an hour, that's the law. The sign can't say reasonable speed as determined by the executive branch. But that went on for months. And you couldn't visit your second home, you couldn't have motorboats. Those are all fine if they come from the legislature, which they did not. So the Michigan Supreme Court struck down the governor's power. In fact, they eradicated the entire act. It did not end there. The governor then pivoted to the health department. And the legislature, perhaps unwittingly, had written some laws that allowed the legislature, allowed the health department in the executive branch to write laws. And those mass mandates came right back. In fact, they came back over the weekend. Fast forward to January of 2022, the Iron Pig restaurant refused to comply with the executive branch orders. They lost their liquor license, they lost their food license. They also had court-ordered mandates from Lansing to close their restaurant under threat of jail. We appealed that decision to this court. On January 13th of 2022, the court looked at the law and said, the standard is this. If there's an epidemic, which isn't defined, and whenever necessary, the executive branch can issue an emergency order to prohibit the gathering of people for any purpose. Extremely broad language. And the executive branch ran with that. They closed restaurants, you had to wear masks, you had to social distance. The court struck down that law under a case of 1803 called Marbury versus Madison. Yes, that's the same James Madison. That gave this court equal co-branch power to strike down laws of the legislature that were given to the executive branch. The court also indicated in that decision that there are other statutes in the health code that will suffer the same delegation flaws. Epidemic is undefined.
The courts say that they may suffer from the same.
Yes.
Okay, but I decline to analyze the statutes because they weren't before.
The court said so they may suffer from the same thing of delegation. But the court indicated that vaping, for example, could be an epidemic, but it's unexercised but available power. So what happened next? So that's January of 2022. In December of 2022, the Court of Appeals decides the Phone versus Ottawa case, which was the Ottawa Health Department on the west side of the state. And in that case, they did not look at the non-delegation doctrine. They simply read the statute as is, as given by the legislature to the executive branch, and said that an unelected health officer, an employee, can tell an elected board of commissioners what to do. And that's true, the law does say that. So the employee trusts the elected organization, but the people have no power there because the person is an employee. So that court said that it's not moot, which is important because I expect the health department to argue that this case is moot. But that published case in December of 2022 said, look, the mask mandate has been off the books, COVID is over, we are still going to decide this case because some type of emergency order in the future is likely to recur. So they decided the merits.
Well, let's look at this case, because you cite 5 different statutes that you're asking me to find violative of the non-delegation clause, correct?
Correct.
2453, 2451, 2455, 5201, and 5203.
Correct.
Which of those statutes were cited by the department with respect to any of the challenged actions or the closing of the Aaron Pig restaurant?
2453 and 2451. And you'll find attached to my complaint an order from the health department.
From this both on 2253 as well as the local health department?
That's correct, yes.
And so it's your argument then that because those statutes, even though 2253, at least by my order at the circuit court level, was excised from the statute, those still are affected and still potentially could be implicated against Aaron Pig in the future if there's a new pandemic.
That's correct. And the court's ahead of me, but reciprocity. Lansing can come, the state health code is divided into state and local. Lansing, the director in Lansing at the state level can come to the local health department and exercise the local health law. That's right in the statute.
So your interpretation of that under 2437, I'm sure is the statute you're talking about. There's no citation that I can find to that statute anywhere in the cases that you mentioned it directly. But the language says that the health department, the Michigan Department of Health and Human Services can exercise any power vested in the local health department, or in an area where the local health department does not meet the requirements of this department. What does that mean?
Good question. That's the difficulty of that. And I don't know what that means.
What's your interpretation?
That the local health department could argue that the area of the epidemic that they have flagged is statewide, and so they don't want to exercise the power, and they prefer that the state government do it.
Well, when it says this part, shouldn't that be or wouldn't that be referring to 2437?
2437 doesn't have any emergency powers associated with it,
Right.
So it would be a dead-end statute then.
So you view 2437 as enabling the State Department of Michigan, the Michigan Department of Health and Human Services, to use any of the other statutes that still survive.
Correct.
24, 53, 51, any of them if they so choose.
Yes, and vice versa. The local health department can use the state law.
Is there any published or unpublished authority that you found from an appellate court that supports that interpretation?
No, they're been challenged.
Right, I couldn't find it, and I was interested whether or not you found it.
I haven't seen anything like that, and we don't know the coordination between the state and local, but we know that the local acted. And actually, there is a connection. When the Iron Pig case began, they brought in a local health order, and they cited 2453 and 2451. Then the state came in and cited their portion of the statute. So they were piggybacking, if you will, on the local health department. So they both worked in concert. The local health department and then the state liquor license and MDAR on the food license all worked together under the state health code to close indoor dining and have mask mandates and regulations and things like that. So it was very circular, ultimately, in this case. And so either one, we could have brought in the local health department, but we took an appeal from the state health department. And that really wasn't on my radar, Judge, until a year after you ruled, when the Court of Appeals in Ottawa, in the public case, said, right on point, the local statute allows the health officer, and by then, a year after you ruled, allows the local health department to come in and issue orders, and the board of commissioners, the elected board, can do nothing. And that's still the law. So the T&B case comes out, Judge, and this would have been in June of 2023. Iron Pig was actually on the same track as the T&B case, but the health department and the attorney general rescinded their appeal. They abandoned it and the case closed, putting their hat on T&B. Well, in my view, Judge, T&B, a published case, is a mirror of this court's ruling. A year and a half after you ruled, T&B comes out and says 2253, the state version, is unconstitutional because it's a violation of the non-delegation doctrine. And in my view, Judge, they incorporated and were well aware of your ruling and had read it. They also said that the epidemic is undefined. And they went further than you did, because you talked about obesity and opioid and tobacco. They said loneliness could be an epidemic. And if people are lonely, then the state health department can start to take some action. And the local health department, because these laws are the same at the state and the local level. But most importantly, T&B addressed mootness and said, so long as the health department disputes the constitutionality of the statute, it's not moot. It's an actual controversy. And they do. They're here. I believe they're going to stand up here and say, we have this power and we want to exercise it. And we may or may not. A decision, and I wasn't able to brief it, Judge, out of the U.S. Supreme Court, and it was only decided March 19th of 2024, so just a few weeks ago, if that. And that's Federal Bureau of Investigation versus FIRKE, F-I-K-R-E. And that is at 601 U.S. space, it doesn't have a number yet, 601 U.S. 2024, in which the FBI placed a passenger on the no-fly list. They challenged the constitutionality of the statute, and the FBI took them off the list. And a unanimous Supreme Court, I think, said no, it's not moot because of voluntary cessation. We could put them back on the no-fly list tomorrow. And it was a constitutional question. That's what got them across the board. So to the extent that mootness and standing and those things are argued, I think that this very active FBI case would put that to rest. But more importantly, yes, it's FBI versus FIRKE, F-I-K-R-E. Decided March 19th of 2024. The number is 22-1178. But I think it's on point on the address, on the issue of mootness. But look at the Ottawa case. There wasn't even a constitutional question there. And in that case, they said this is an important public issue. And there wasn't even a constitutional question. And then T&B, which finds a constitutional question, spends an elaborate amount of time talking about the fact that the case is not moot. And I think stare decisis binds the court to decide that case. There was some discussion by the health department about local legislatures are not bound by the non-delegation doctrine, which was an interesting argument. Most of the cases are decided before they're certified, but I think you can put that to bed by saying that this is state law. This is not a local ordinance that was drafted, even though a local health department has that right. It's all under the state law, and the state Department of Health can exercise those rights. And I cite the Michigan Constitution that still says, even if it were, it's the Board of Commissioners that write the law, no matter what. I mean, I don't think James Madison has ever deviated from that argument that the legislature writes the law because they're accountable to the people. And if the health department was correct about that, then a place like Wayne County that has 1.7 million people is going to be subject to these state health laws. We have 100,000 in our jurisdiction, which is Antrim, Charlevoix, Emmett, and Otsego. Keweenaw is only 2,000 people, but I think they care. I think those 2,000 people in Keweenaw do not want to be subjected to this legislation. And so, whether or not the executive branch person is elected is irrelevant, quite frankly, because the governor was elected, and that was struck down. But here, we have an employee, and the power to write laws does not belong to the executive branch. And I think that's as clear of an argument that we can make. I want to talk a little bit about what the court was talking about a moment ago. For the people that may not have read these laws, this nice lady gave law writing power to this nice gentleman in the executive branch. But what are the rules that he has to follow if he wants to issue an emergency order? On a 2453, which the court struck down on the state counterpart, just that there's an epidemic and it is necessary to protect health, he issues the emergency order. But who gets to decide the emergency? The people? No. The executive branch decides the emergency. So they control the definition of the emergency. 2451, declare that there's an imminent danger that a condition could reasonably cause disease. That's it. Once they make that determination, they can start issuing orders, closing restaurants, having us wear mask mandates, whatever else they want to do. But you see, as the court is well aware, this is the danger James Madison does not want. That branch has the power of enforcement, and that's where the difficulty lies. We want this officer to have a firearm because he must enforce the law, but he doesn't get the pen. He doesn't get to write the law. He gets to enforce the law. And this nice lady gets to write the laws. She has a lot of power, but she doesn't get a firearm. She can't enforce the law. And then the court gets to interpret those laws on the constitutional basis. So 2451 also allows them to prohibit the presence of individuals. Very broadly drafted, no definitions. 2455, any building that could reasonably believe to be the cause of disease based on the condition. Now that's going to be a restaurant, or better yet, a school. If they find that COVID or some other disease or loneliness or anything that's an epidemic, they can close the school under 2455 because the building itself is the cause of the disease. 5201, if the officer reasonably believes that somebody harbors an infection, whether or not it's present. So you just look at somebody, and the other criteria is there an unwillingness to conduct himself in such a manner as to not place others at risk? That sounds a lot like COVID and social distancing. And
It seems
again,
to be a lot more clear guideposts than reasonable and necessary, though. Would you agree?
yes, but it fails the definition of a law judge because it's not a law yet. And a law must be a law when it leaves Lansing. That's it. It can't become a law. And a law writing belongs to the legislature, but by doing this, they're giving the executive branch broad powers to write laws when they feel like it.
It appears you recognize that there can be some sharing between the coordinate branches, so long as the delegation does not violate the anti-delegation or the non-delegation doctrine. You cited the case, the imminent case from the Michigan Supreme Court.
Right.
You cited and relied upon it in your brief. It says that you can have that coordination, you can have the delegation so long as there's some reasonable exercise of discretion or channeling of the exercise of discretion, right? So the question is, does 33.5201 have more guideposts which channel the exercise of discretion of the director, local health director, and MDHA's director or otherwise, more so than 2253, which I struck down?
I think that 5201 has the word reasonably believes, and that word struck down the Emergency Powers Act. And the court got the other half of that equation by the word necessary. Reasonable and necessary were in that statute, and both those caused the demise of the statute. The court only had necessary, and that was struck down. So this is reasonable. I think reasonable is worse. It's more broad. It's in the mind of the person. And those that support the delegation of law from one branch to another, and I have found less support for that over the years, Judge, having done this for 4 years now, that I'm not the biggest fan of the non-delegation doctrine that I used to be, because it can be manipulated, and I'll come to that on the vesting clauses in a moment. But that is the law under Ingrate Certified. But these also fall for indefiniteness. There's no time restriction here that how long these mandates can stay in place, and that causes the fatality of it. And the same with 5203. If you're determined to be a health threat to others, you get a warning notice, and it can be oral, just a verbal notice, and you're required to cooperate. I don't know what that means, but it's very broad. Then it goes on to say they can require treatment programs and require medical testing. But these laws were well intentioned in 1978, which was a long time ago, but they were never used.
Would you agree that 5203 is more protective to the individual than, for example, 2253? For example, 5203 allows the department to issue a warning notice. It allows the department to say what an individual must do, engage in testing to make sure whether there's a disease and so forth. But then for enforcement, they need to apply to the probate court, and then there's a due process right. That was an opportunity to be heard. Would you say that's more protective or less protective?
It's more, it is, right? You have the right to go to the probate court. And ironically, one of the suits I filed in this county on the school mask mandates, I filed in the probate court. And Judge Cooper looked at it and said, no, I don't have the jurisdiction. We came to this court. Judge Mercer was assigned to that case. So now I'm concerned about that because I did go to the probate court and I was told we don't have jurisdiction. So now what happened? And that was a written opinion by Judge Cooper. So now we have precedent in this county that really the probate court doesn't have the authority.
Well, but that wasn't on this section, right? You did file suit number 5203.
Yes.
You did.
I did. And cited that probate section.
All right.
So
you determined that the probate court did not have jurisdiction, despite that.
that's correct. Yeah. And so that that is Let Them Breathe versus local health department, and that would have been filed in 2021 in September. So the court should be able to find that, or if you ask me to submit that to your staff, I'll do that. So the court said more of a probate court on wills and trusts and those types of things, and the state argued, the county argued, that he lacked jurisdiction. So he came to this court under the circuit court, and I still believe that the probate court is the proper venue. But I hear
Whether or not it's probate or circuit, though, that the individual citizenry has the ability to address the grievances in court. Does that make 5203 better able to survive a non-delegation challenge?
it's got a better shot at it. I'm concerned about the earlier language in there about that they get a statement that requires the individual to cooperate. A person could just cooperate and not know they have a right to go to probate. About that. And what happens, Judge, if the health department issues an order under, and they cite 2453, 2451, 5201, 5203, and 2455. Now we've got a basket here, which is what happened on the mask mandates in the school cases. They wrapped up all those statutes, 2453 and 2451 for sure in the danger. So then what happens to the basket? Half are clearly unconstitutional and some are more suspect. But I stand on the premise that they're going to need a lot more guidance if we're going to allow delegation And what they should be doing is, which is in my complaint, and we just have some limitations on our briefing, is fact finding. If the legislature says to the executive branch, if you find these facts, you can then issue this order. But I want to see court relief in 2453 and 2451, 2455. The elephant in the room is the legislature has the power right now. So if this is what the public wants, then write a law that would require mandates under certain circumstances. But as I think the court just pointed out, 2453 was the most dangerous because you can prohibit the gathering of people for any purpose, just when it's necessary for an epidemic. And if the we were getting cases in which the courts were saying they were moot until T&B. And T&B said, we need to decide these cases. And so did Ottawa. And now the Berkey case out of the U.S. Supreme Court most recently.